Okay, very briefly on bonds, because it's very similar to the legislation you currently have. But the one major change is that regardless of whether it's furnished or unfurnished, the bond limit is 4 weeks of rent. Okay, that's it. 4 weeks of rent. And the other one, I can't imagine any agent being involved in it, but it's now permissible to pay a bond by instalments. Now, again, from practising agent point of view, I can't imagine any agent saying, well, if you haven't got the bond up front, guess what? You're not going to succeed with this application.
Does that entail refunding existing tenants? We've got say 2 dozen furnished premises and they've paid 6 weeks bond. Do we have to refund them?
It could actually happen, because whilst the legislation acknowledges previous and existing tenancy agreements, they'll all need to deem to comply. And if you've got a 6-week bond on a property, you still got properties under $250 a week? No. Right. I'm not going to get into this.
That's a no.
Yeah, but I think that's what you're going to have to do. It'll have to be back to 4 weeks of rent. But the problem is there is no provision for any top-up. So if you've got a tenancy that's been there and rolled over numerous times, then the original 4 weeks of rent is the bond and that's it. So the only way you can possibly get round it is to actually have a brand new tenancy. Yeah, the only thing that worries, that's been put forward, the only thing that worries me is the tribunal is already on record that a new tenancy agreement really only acknowledges an existing tenancy. So it just puts another fixed term in. So it's not a brand new tenancy. And when you can top up is when you've got a brand new tenancy.
That's going to put even more pressure on the rental market.
Absolutely. No question. Okay, so that's about enough to tease your mind. Oh, well, one thing that's a bit of a bonus from our point of view, with your bonds collected on a monthly basis, you must account to the Rental Bond Board within 10 days after the end of the month. So your bond accounting can be now put to your end of month run.
You don't have to do it 4 days, 7 days.
No, they've allowed it to be 10 days, within 10 days of the end of the month. But don't start it now, wait until the new legislation starts. Okay, the next one is Tim's favourite, is water usage. I think overall, there's a bit more work in it, but I think it's going to help us regiment some of our owners, those ones that discover they haven't collected their water usage for a year and bring a whole lot in at once. They've got to be, those type of owners need to be warned. Before I get on to that, the requirement to collect water is now going to be restricted to water efficiency devices. If they're not fitted to a property where you're entitled to collect water, then you can't collect the water. No. Now,
that's why it's my favourite. I find this quite. I have my 2 bobs worth. Here. I find this just.
It's Tim and Tim show here.
Yeah, you've got gas. It's easy. You've got electricity. That's easy. And for some reason with water, they turn it into this political statement that the only way you can collect the water charges is if there's these efficiency devices fitted. That's one of the criteria, or an essential criteria. I don't get it. I mean, if I'm a tenant and I say I don't care about water efficiency, I can do that as a private owner. I don't care. I'll let it pour down the sink. I pay for it. But I'm not allowed to do it as a tenant. And I can't negotiate, as I understand, and take opposition with me if you will, but I can't negotiate with the landlord and say, I'm happy to pay the water charges. I'm happy to do it. I don't want you to install your water efficiency devices. I'm happy to pay it. But if I'm able to convince the landlord into doing that, 10 years later I'll turn around and say, well, I want all that money back because...
You haven't complied.
You haven't complied.
It is.
So you reckon there's going to be some conflict here? I mean...
I think so.
Is the government going to provide subsidy for landlords to retrofit?
Yes. Yes, at the moment you've got a system that runs... most of you within the Sydney Water area? Anybody outside Sydney Water? Okay. this probably won't apply to you. Have you got the water fix program working in your area?
The water,
Water fix, which is your authority supplies the bits and pieces, the exchange pieces, and no. Well, Sydney Water have this program going that they will actually put up the shower heads and put in the restrictors and those sort of thing at a cost of $22, all right, per property. That's fine, I suppose. For you people outside that area, then you've got a situation where you have to buy the fittings in and then pay your normal plumber's rate. So that takes you $22 away, doesn't it? And it's considerably more. For those that are in the Sydney Water area, that program is due to expire on the 30th of June 2011. So after that, you'll be out in the open marketplace regardless. And Tim's right, it's a decision your landlord's going to have to make. If the tenant says, look, I don't want those things restricting my water use, I don't want them in there, but I'll pay for the other thing, well, the landlord's going to have to make a decision because, again, Tim's 100% right, that down the track, if they've not fitted with there, they can claim their water usage back. All right, now what's the next one we want to talk about? Fixtures and bits and pieces. Section 66. It's under what they call Division 6 of the bill, and it refers to alterations and additions of residential premises. A tenant must not, without the landlord's written consent or unless the Residential Tenancies Agreement otherwise permits, install or cause to be installed a fixture or make or cause to be made a renovation, alteration or addition to the premises. So the landlord's got some rights back there. They actually have to make an application. The landlord has to consent. Okay. Now the second part says that the landlord will not unreasonably withhold consent. So if the landlord says no, go to hell, then the tenant has a right to go to the tribunal and say that the landlord's, or make the case that the landlord's refusal is unreasonable. The part 2, it says that it may not unreasonably withhold consent to the fixture, alteration, addition or renovation. That is of a minor nature. There is no definition of what is a minor nature. So again, we have some hope that there will be a definition in the regulation, but there's a fair chance it probably won't be there at all. Part 3 says that a landlord may withhold consent to any other action by the tenant that is permitted under this section, regardless of whether it's reasonable or not. So that gives a little bit more negotiation power to the landlord. The right to remove it will be done at the cost of the tenant. But there's no requirement in there for the tenant to use any sort of qualified person, any tradesman or anything like that. So you're still in the situation in the lap of the gods as to whether or not the tenant can actually remove the fitting without damaging the property. So that's a bit of a worry.